Did Senator Whitehouse just reveal that Bondi and Patel misled Congress about Epstein and Mar-a-Lago? And did he catch them on the record? In a stunning hearing, Whitehouse accused the Attorney General and the FBI Director of making statements that don't match court records or publicly available filings. Watch closely, because if Whitehouse is right, this committee is standing on the edge of a constitutional fault line.
Thank you very much. I'd like to make 2 points. The first has to do with Arctic frost and the information, Chairman, that you released the other day. It's been described as a politically weaponized investigation, but I ask my colleagues, should there have been no investigation of the raiding and the ransacking of the United States Capitol? Of course there should have been an investigation. And by the way, I was with many of you during those dark hours, and there was no doubt in anybody's mind in the Senate at that point that crimes had been committed and that they needed to be investigated. So please, let's not pretend that the fact that the FBI investigated the raiding and the ransacking of the United States Capitol is itself in any way politically weaponized. That is their job. To the question of senators being in the list of toll record investigations, I'm eager to get to the bottom of that. I think we should get to the bottom of that. But let's remember what this was. This was toll records, which for those of us who've been prosecuting for a while is similar to a pen register, which is where in the old days the phone company would clip a register onto the wire, and you wouldn't know what was said. You would only know what number called what other number and for how long. When you have what prosecutors would call predication, to put a pen register on one number, you necessarily pick up everybody else who was called. That doesn't make them the subjects of any investigation. Similarly, if you're running a wiretap, and by the way, a pen register is not a wiretap, and senators on this committee should be knowledgeable and scrupulous enough not to confuse the two. But were this a wiretap, the same thing would take place. If, as U.S. Attorney, I got a wiretap on a Rhode Island mobster, and that mobster called the butcher, the baker, or the babysitter, the butcher, the baker, or the babysitter are now swept into the investigation by virtue of having been called. It doesn't make them the subject of any investigation. And with wiretaps, it works that you have minimization procedures, so you shut it off and so forth. But this wasn't a wiretap. This was toll records, the modern equivalent of a pen register that only shows who was called. So before we start to reach irate conclusions about weaponized FBIs going after people, it is worth taking a calming step back to consider the possibility that the FBI had proper predication for certain phones, and that those phones then called the senators. I don't know what happened, and I support the chairman's desire to investigate this. But we should investigate this without reaching dire conclusions before we have the evidence. Because there is a very clear investigative scenario in which the FBI has proper predication to get toll records, or in the old days, a pen register on an investigative target's phone, and then necessarily everyone the target called comes into the toll record, comes into the pen register. That's just how it works. That's what investigations are supposed to do. And if there's proper predication, you then go to the second step to see if there's a basis for investigation of the person at the other end of the call. So let's just understand that we shouldn't be drawing a lot of irate conclusions before we know what the facts are in the context of how such investigations actually work. Here's the second thing, and this goes back to the ranking member's comments about yesterday. To me, yesterday was an awful day in the history of this committee. It set new low after new low after new low. And I'm not going to talk about all of the new lows. I'm going to talk about one in particular. And that is whether anybody noticed the irony that the day before the United States Department of Justice arraigned a former FBI director for allegedly making untruthful statements to this committee, the Attorney General of the United States sat right there and made untruthful statements to this committee. And they weren't maybe untruthful statements. This wasn't a question of nuance. She made allegations about the ranking member and me having received political contributions from some, she said, Epstein close confidant. Well, guess what? That's actually checkable. There's a thing called the Federal Election Commission. The Federal Election Commission keeps a website that tracks all of our contributions. An intern at the Department of Justice could have checked to see that the allegation, I'll leave it to myself, that I had received campaign contributions from this individual, that was false. And it's not a maybe answer, it's a yes or no. Did I or didn't I? And there's an unimpeachable record that shows that what she said sitting right there was not true. If we are going to care about untruthful statements made by the Department of Justice and the FBI in this committee, let's not have this be yet another area where there are different rules for one party than for the other party. And just by the way, on that very subject, the other thing that the Attorney General did sitting right there was to strip all cover away from the untruthful statements that had been made to this committee by the current FBI director. You all heard him here. He said that he couldn't tell us about his grand jury testimony in the Mar-a-Lago case, where he first pled the fifth, then got immunity, and then testified. He couldn't tell us what he testified to, he said, because the Department of Justice had sealed the testimony and because there was a court order barring him from doing that. And he actually identified which judge, the chief judge of the DC Federal District Court. Well, guess what? We know that since then, the chief judge of the Federal District Court has said that that was not true. He said specifically nothing prevented Director Patel from discussing his grand jury testimony. And yesterday, the Attorney General had the chance to say, you're right. We did seal the testimony in that matter. The Department of Justice did seal the testimony, and Patel's statement was true. Not about the court order, but at least it was sealed by the Department of Justice. She didn't say that. So now both his testimony that the DOJ had sealed his testimony and his testimony there was a court order barring his testimony are kind of demonstrably false statements to this committee. And then when he came back and we challenged him on those false statements, his second false statement was to say, I'm not going to answer any of those questions because my transcript of the grand jury testimony, I've worked with the DOJ to see that it is publicly released. Well, it either has been publicly released or it hasn't. It's a very simple distinction, yes or no. And we all know that it has not, in fact, been publicly released. And when we asked about that from the Attorney General, again, she left him high and dry and refused to say that anything had been publicly released, that there was any publicly released transcript. So yesterday stands in really stark contrast, I should say the day before yesterday stands in really stark contrast to yesterday. Yesterday, an FBI director was arraigned for making a false statement. The day before that, the Attorney General of the United States made arguably even falser statements. We'll see how the other case turns out. And she left the current FBI director completely exposed on his multiple false statements that his grand jury testimony in the Mar-a-Lago case had been sealed by the department, was under court order not to be released, and had since been publicly released as a transcript. I don't know if this committee is going to take itself seriously enough to treat false statements to this committee as serious matters, irrespective of who made them. But the contrast is really stark. Thank you, Chairman.
This hearing wasn't business as usual. It was a test of whether accountability still lives inside the institutions built to enforce it. Senator Whitehouse didn't deliver outrage, he delivered proof. And in doing so, he revealed something larger than two officials' lies, the hollowing of the very system that's supposed to guard the truth. He began with irony so sharp it drew blood. The Department of Justice had just arraigned an FBI director for lying to Congress. The next day, the Attorney General sat before that same committee and did the same. How can a department prosecute deceit in the morning and practice it by afternoon? Whitehouse called it plainly. Bondi claimed he and the ranking member had received campaign donations from an Epstein confidant. It wasn't opinion, it was verifiable fact, or falsehood. The Federal Election Commission's database showed it was false. An intern could have checked that, he said. So why didn't the department that defines truth in court bother to confirm it in Congress? That question lingered longer than any headline. Because if the top of the justice hierarchy no longer respects its own evidentiary standards, what happens to everything beneath it? When the enforcers abandon verification, who enforces the enforcers? Then Whitehouse turned to the second revelation, the one that stripped away all remaining cover. The FBI director, Patel, had told the committee he couldn't speak about his grand jury testimony in the Mar-a-Lago case. He cited a court order, he even named the judge. But the chief judge later said no such order existed. So what was that? Confusion or choreography? The Bondi could have corrected him. She didn't. She could have defended the truth. She didn't. Every silence became an answer. Every omission, a decision. And that's the deeper rot Whitehouse exposed. A Department of Justice that has learned the art of selective accountability. One standard for the prosecuted, another for the powerful. One law for the subordinate, another for the superior. How long can a republic survive on conditional truth? This isn't about partisan rivalry, it's about procedural decay. Because once the guardians of law begin treating lies as strategy, the entire edifice of enforcement starts to collapse inward. A false statement at that level doesn't just mislead. It trains the institution to tolerate deceit. Whitehouse's method was methodical. Cite, verify, expose. No theatrics, no raised voice. Just the weight of documentation against the lightness of denial. That restraint made the indictment cut deeper. When officials can fabricate with impunity and their peers avert their gaze, accountability becomes theater. He ended where every institutional crisis ends, with contrast. One day, Patel arraigned for lying to Congress. The day before, Bondi lies to Congress, uncharged, untouched, unbothered. What lesson does that teach every agent, prosecutor, and citizen watching? That truth is negotiable, that law is leverage? Because if the Department of Justice can't be trusted to tell the truth to Congress, then who exactly is it protecting? The public or itself? That's not oversight, that's entropy. And as the gavel fell, the silence that followed said it all. The institutions meant to defend justice weren't merely under strain, they were complicit in their own collapse. If equal standards die quietly in rooms like this, what's left of the republic beyond procedure and pretense?